Hello, I'm Rex Hogue, and this morning we're going to be talking about trusts. What is a trust? A trust is a contract that involves three parties. The first party is called the trust maker. That's what we call them, but they have other names: creator, grantor, settlor, trustor. But we use the term trust maker because it's simple: the person who makes a trust. That's the person who creates the trust. They determine what the terms of that trust will be, i.e., what the rules are of the game. They decide who's going to be the trustee. They decide who's going to be the beneficiary. They decide under what circumstances that trustee is going to serve. And they determine how much the beneficiary receives when they receive it and how the beneficiary receives it. The second party to this contract is the trustee. The trustee is the boss. The trustee's job is to manage the trust for the benefit of the beneficiary. But the trustee has to do that according to the rules the trust maker set up. The beneficiary is the third party. They benefit from the trust according to the terms of the trust that the trust maker created. Now, in a typical revocable living trust or living trust or revocable trust, the trust maker names themselves as the trustee and as the beneficiary. Now, the trust is designed to own assets instead of owning assets in individual names. That process is referred to as either the asset alignment process, which is a term we usually use, but it's also known as funding, getting the assets funded into the trust. And what that means is that you name the trust as the owner of the account or the asset, and you typically will do that if it's an account at the bank, for example. You have to go to the bank and sign a new account card naming the trust as the owner. If it's real estate, you sign a new deed and you record that deed in the deed records. Now, to the extent that you've done that, trust will avoid both guardianship and probate. Now, how is it that trusts do avoid guardianship and probate? Well, the reason is the trust never dies. The trust never becomes incapacitated. Unlike people, the trust will be there until somebody decides to stop it. So assets, therefore, are not subject to guardianship and probate because those are triggered either by incapacity of a person who owns assets in their own name, or probate, which is triggered by the death of someone who owns assets in their own name. Since the trust doesn't become incapacitated or die, it avoids guardianship and probate. Now, what does funding the trust or asset alignment entail? Well, basically on bank accounts, for example, I already mentioned, you go to the bank, you sign a new account card. And deeds, you have a deed prepared by an attorney who is licensed in the state where that real estate is. And then you record that deed in the county records. That same thing may apply to mineral interests. And natural resources are typically rights. They can also be done by deed. Personal property and collectibles are typically done by an assignment. We use an assignment of personal property to transfer that stuff into the trust at the same time the person signs the trust. For stocks, bonds, mutual funds, brokerage accounts, and non-qualified annuities, those are done through your financial advisor or through a company, and you kind of follow the same process you do with the bank. Life insurance, you do that by having the policy owned by the trust, and then you name the trust as the beneficiary. Rental equipment, typically it depends on what it is, whether it's titled or not. If it's not titled, you can do that by assignment, and then you just rent it out, and the rentor pays the trust for the use of that. Intellectual property like trademarks and copyrights are typically transferred through the trademark office. And then business interests like corporations or LLCs or partnerships, those are transferred through the corporate documents or the company documents. We rarely see corporations these days. It's mostly LLCs, but some limited partnerships. Now, life insurance, you transfer the ownership, but there is one kind of life insurance that you can't transfer the ownership of, and that's employer-owned life insurance. Because you don't own it, you can't transfer it, but you can change the beneficiary, and you definitely want to do that. So for all the things I've talked about up to now, if there is a beneficiary, you want the trust and not a person to be the beneficiary. And you also want the trust to own it. Now, when you get to things like non-qualified annuities and life insurance, you want the trust to be the beneficiary, as I just said. Here's the reason for that. Let's suppose a husband and wife, the husband dies, and he names his wife the direct beneficiary designation, but she's incapacitated. Now that money goes in her name. How does she cash the check? Well, the answer is she can't. She now has an asset in her name, and that will force a guardianship. If the trust were named as the beneficiary, the insurance company would pay the trust or the trustee. The successor trustee would take care of the wife. And it would be done far faster and at way less expense than naming an individual. Now, there are certain assets that we can't give you direct advice on because they're very fact-driven. What you do with qualified annuities, IRAs, 401ks, qualified retirement plans, pensions, those become very fact-driven, especially after the Secure Act of December 20th of 2019. Personal automobiles, we typically don't put those in the trust in Texas. For boats and aircrafts and yachts, all of our yacht owner clients, those assets require more individual planning, and it's hard to give general advice. So when we get finished with that process, the trust should own your cash, your checking, savings, CDs. It should own your real estate and mineral interests and natural resources, your personal property and collectibles. It will own your stocks, bonds, mutual funds, non-qualified annuities, life insurance, rental equipment, receivables, and business interests. And it'll be the beneficiary of non-qualified annuities and life insurance. Again, the trust should not own personal automobiles, and you don't want it to own qualified retirement plans, because if you transfer those into the trust, that is a taxable event, and you will have to recognize and pay the taxes on it because that would be a distribution. You can name the trust as a beneficiary of those qualified plans, but whether you need to do that or not depends on your particular situation. So the bottom line is a trust is nothing more than a contract. They're fairly simple in that sense, though there's a lot to putting a trust together and doing it well. But again, it's a three-party contract that involves the trust maker, the trustee, and the beneficiary. Thank you.